Number 75, matter of Aikens.
Ready at the floor, please?
Thank you, Judge. Ready?
Yes, please proceed. Do you want rebuttal time, counsel?
Yes, thank you, Your Honor. 3 minutes, please.
3 minutes, you have it. No problem. Go ahead.
Good morning, Your Honors. My name is Mary Davison, and I'm here to represent the appellant in this matter, Kenneth Marknell. I would respectfully submit that the court should not carve out any exception to the bright-line rule of Shondell J. That is, that that equitable estoppel is available to children in paternity and support actions, and will always go to whether that accomplishes their best interest. Because the question here should not be one based on economics or based on dollars and cents, but based on the right of the child to maintain an intact relationship and an intact family. And as the record below shows, that is exactly the situation that was presented for this child, Angela S.
But this is not the usual case for that kind of a
Not
hearing.
usual in the sense of what the court articulated in Shondell.
Right. Mm-hmm.
Certainly the court listed 3 possible situations, that is, where mom's trying to divest her husband
Right.
of a relationship with the child, where a biological dad is coming in and trying to divest a husband or whoever of a relationship with the child, or where the husband is coming in and asserting some kind of right. Essentially, though, the test is that there's an established and intact relationship, and the court doesn't want to disrupt that relationship.
Right. Well, the child is what's central in the...
Right. And that holds in this case as well.
There was no best interest hearing here, was there?
There was none. This was rendered on summary judgment, and so the court below had no record made with respect to how this child was going to be impacted. We know from the motion papers on the summary judgment that this child had always lived with the husband-father figure, that the husband-father figure's name was on her birth certificate, that she used his surname, that she had 2 half-siblings within the family, and all those things
So
are...
you want us to include this scenario in the list that you just gave us from Shondell?
Yes, I think this is simply...
What would happen, what precisely would be the issue with the hearing? The court would essentially decide, would the issue be essentially there are 2 possible fathers, I'm going to decide which is the father?
I think the court has to decide what would be in the best interest of the child.
But more precisely, I mean, is your position this child only gets one father and the court has to pick it?
I think Judge Smith, the cardinal rule here is the child's in an intact family. One of the problems is...
But I mean, in some sense, I understand it's the best interest of the child, but in a sense it's the best interest of the child to get money from as many fathers as she can get. But that I take it you think is not the correct understanding of best interests.
This court has ruled repeatedly in Shondell, in just last term in Mark T., that the child has an interest in remaining in an intact family
Well, in
unit.
this particular case, is there a question as to, you know, what you're looking for, as to what the emotional impact is on the child? Is it helpful to her for him to be determined the father, even though apparently she knew, right?
I don't think, this court has repeatedly held it's not an issue of biology. It's not an issue of dollars and cents. It's an issue of how it impacts this specific child.
Right. In this particular case,
Yes.
what is your concern?
My concern with respect to the child?
Yeah, what would be
Is she's
gained by a hearing?
She's torn out of this family, both legally and literally.
Well, as I understand your adversary's position, or at least what might be your adversary's position, we don't want to tear her out anything. She can stay right where she is, live the happy life she's living, and just get an extra check every month. How's that for best interest?
We don't know that for a fact, Judge Smith, because if my client is adjudicated to be the father of this child, then he has other rights that fall in line with that. He has a right to seek custody. He has the right to seek visitation. And
you may be right, but I'm not sure that they would necessarily agree with you. They would say at that point estoppel kicks in. Estoppel can be used against you, just not for you.
well, that's what the Fourth Department
And
ruled.
you're saying that's unfair.
And I'm saying it's not only unfair to my client, it's unfair to the
And
child.
does this hearing that you're talking about occur before or after genetic marker testing?
Well, this kind of segues into the right to counsel issue, because In fact, when my client made his first appearance telephonically, the support magistrate failed to advise him of the second two rights under 262 of the Family Court Act, those being the rights to assignment of counsel and the right to an adjournment.
Why did he immediately agree to DNA? Because he didn't have counsel in your mind? Or
The
that he wouldn't have
magistrate...
done, that he might not have done that if he had assigned counsel or anything?
It would be speculative, of course,
Yeah,
but
right.
what's clear from the record is that my client had concerns about this estoppel issue. My client's not a lawyer, he's a pool cleaner,
Right.
and I couldn't articulate it along those lines, but it's clear that he...
What would counsel have done at that point? Use
Yes,
Section 532 of the Family Court Act?
Yes, 418 and 532, and ask for ask for a best interest determination before genetic marker testing was accomplished, and
So the sequence is the best interest hearing before the court determines whether or not to undertake DNA testing.
Statutorily, that's required if any party or if the magistrate himself, in this case, had an issue with respect to estoppel. I think the statute requires a best interest adjudication.
And if that doesn't happen, because we've got I guess we've got half of the reverse here, then how do we handle that?
I'm sorry, are you saying...
Well, now we do have the DNA tests that show, a 99.9%.
And certainly that's a factor.
Parenthood.
And the child relies heavily on the fact that she's aware of the results of the genetic marker testing. But I think it's only a factor. And nowhere in family court law has this court or
I guess my question is the damage already done so that there's no sense to the remittal?
There's some damage done, but there's always sense to the remittal, Judge Graffio, because we don't know how any of this is impacted upon the child. There's been no determination by the lower court, and you can't make that determination, or excuse me, the Fourth Department couldn't make the determination on the record, because all they had were self-serving affidavits of the parties.
Is there also, even if the damage has been done, is there another problem that it's not a good idea to let them win the case by doing the damage to the child and then saying, oh, the damage has been done?
Yes, Judge Smith, because as a matter of policy, we don't want to encourage mothers to be going around telling their kids at age 10 or whatever age it is, hey, by the way, daddy is not your daddy, and I'm telling you this, and I'm going to go after your true father for support. As a matter of policy, that usurps the family, it usurps the child's right to an intact family relationship, and I don't think the court wants to promulgate that as a rule statewide.
What's the sequence? What should have been the proper sequence of events in your view here?
The magistrate should have advised my client of his three rights under 262 of the Family Court Act. I would hope at that point, and I believe based on what I read in the record, that my client would have asked for an adjournment and asked for an assignment of counsel so that he could discuss this with counsel.
Okay, all that's happened. Now what happens?
Counsel moves for a best interest determination. And at that point, a best interest determination is rendered, and the parties live with whatever that is.
And the blood test never happened. If you win the best interest determination, the blood test never happened.
I would submit so. Obviously, if it goes back and there is a best interest determination and it's adverse to my client, the blood test has been done and perhaps it's admissible at that point.
What about an equitable estoppel hearing?
I think my client should be entitled to invoke equitable estoppel on behalf of this child because...
Well, I mean, the sequencing, why wouldn't that come before the best interest hearing?
Well, I believe under the statute, he has to raise the issue of equitable estoppel, and then the magistrate...
Well, we're assuming he had a lawyer, I guess, so that would be raised.
Yes.
And then that would proceed first.
And, right, there'd be a best interest determination, and then based upon whatever the result of the best interest determination was, there'd either be GMT order...
Are equitable estoppel and best interest separable, or are they the same thing?
No, I think they're two different things, Judge. I think that...
So it could be, suppose, well, explain how they come out differently.
Well, because I think the estoppel is a tool. I think the best interest...
But I thought in Shondell we said estoppel is based on best interest. You can't estop someone unless it's in the child's best interest.
That's what you said, yes.
So how do you have an estoppel hearing in which the best interests of the child are not considered?
I think you should have had an estoppel.
You say best interest should be part of the estoppel determination?
Yes.
I guess I'm really getting it. Are we looking at one hearing or two here?
One. I think once there's a preliminary determination of best interest, the parties are bound by it.
Was there any contact between your client and this child Before this family court proceeding?
It's an issue, it's one of the facts an issue that should have mitigated against a summary judgment, but my client admits to 2 very brief phone calls around the year 2000.
He also claims that the other father told him to stop calling.
Yes, during the second telephone call, the father figure took the phone away and said, "Don't call here anymore." So there's an issue of alienation, too, that might go to the support,
Did
but
they
that
ever
wasn't
meet?
raised
Was
below.
there ever any physical
According to my client's affidavit, no.
visits?
No, and I think that's an important consideration, too, because we're not talking about some of the cases that say the child,
So this is a man she's literally never set eyes on in her life?
yes, I believe so. I believe the record shows that. Yes, and I think that's an important consideration because when we're talking about removing or erasing somebody's name from a birth certificate and typing in somebody else's name, gee, it'd be nice if you had met that man at some
Yeah,
point.
well, this goes to the total contextual picture from your perspective.
Right, the best
Yeah.
interest that should have
Yeah.
been accomplished.
Yeah.
Do you know of any other cases where equitable estoppel has been used as a sword rather than?
I couldn't find any. The Fourth Department cited 2 cases, Dowd and Ruby M.M. I think they're distinguishable factually because they were best interest determinations before.
Dowd looks a lot like this one to me.
Again, I think there was a best interest determination based, if I'm not mistaken, there was a hearing, and the court made that determination, and the court may well do that on remitter, but the point is the court below, the family court, didn't do that, and I just don't think you can guess what would be in the best interest of the child without some kind of fact-finding.
So you think this is consistent with the spirit of Chandel?
Absolutely. It's absolutely consistent to not allow this kind of niche. And remember, the cases cited by the Fourth Department were handed down prior to Chandel coming out. One was, I think, 2003, and one was 2005. So,
But without a best interest hearing, we don't know what the circumstances are. For example, what if the family that the child was with is destitute financially? We don't know that. And maybe it would be in the child's best interest to seek support from your client.
yes, Judge Sapir, finances, by case law, definitionally, finances are a portion of the best interest determination. I see my time is up. Maybe I'll get to the
Okay,
other
Counsel,
issue.
you'll have a rebuttal. Yep,
Thank you.
thank you. Counsel, go ahead.
Good morning. I'm Susan Gray Jones, and I am the attorney for the child, Angela S.
Why shouldn't we have a best interest hearing here?
Well, Your Honor, I believe that the statute requires not a hearing, but the judge to issue written findings after consideration of the issue of equitable estoppel, which I think by its definition includes best interest.
Don't you need a hearing to determine the best interests here? How could the judge know what's in the interest of the child without having some of the issues that we just discussed?
Well, in this particular case, there were motion papers submitted both by father's counsel and mother's counsel, and there was a verbal report by the then attorney for the child.
You say there has been a best interest determination?
Your Honor, I think the lower court judge, when he issued his decision, articulated, albeit briefly, why he felt, based upon the papers submitted and the facts that he knew.
The appellate division didn't do that, did it? I mean, as I read the appellate division, they basically say that a biological father defending a support proceeding can't use estoppel to get off the hook.
That's correct.
Is that a good rule?
Yes, it is. I agree.
So that essentially the biological father always loses in a support proceeding.
Well, I wouldn't say that he loses. I would say that he has to live up to his
Always
legal
has to pay.
responsibility.
So what's the purpose of Section 532, though, that seems to indicate that you could ask for the hearing before the blood test?
I think that applies, Your Honor, in cases where there is a non-biological father who has held himself out as the father of a child and supported a child who then wants to say, okay, no, I'm not the father anymore.
I know you're a very experienced law guardian, and you're, to me, a kind of a tough situation here. Wasn't this pretty cruel to this child, at least on its face? I mean, here's a little girl that thinks that her father's been living with her for all this time, and all of a sudden he or she decides to say, I'm not your father's down in Florida. And there's a phone call, and all of a sudden this guy finds out that he's got a daughter who's now 12 years old that he's never met.
What I think is cruel, Your Honor, is that my client, who's now almost 16 years old, and as many teenagers as I'm sure you all know, is very invested in the idea of fairness. She sees the appellant's position in this matter as a betrayal.
Yeah, but,
He is my father.
is the child solely, able to make that determination, or does the court have an independent duty to look at exactly the kinds of things that you're saying, the emotional impact on the child, and this is a father that, as we just discussed, that she's never seen, and, how does this all affect her? Isn't that something that the court has an obligation to look at, and not just say, well, the child says this is about fairness, and isn't that something that the court should look at?
I think in the larger scope, yes. In this case, as an advocate for the child, at the lower court, the then law guardian advocated her position, which was the same then as it was when the appeal was pending before the Fourth Department, and as it is today.
Yeah, but what's the court's responsibility?
Before this revelation to her, she didn't have this stress or problem, did she?
But it did happen, Your Honor.
Would you recommend that this happen tomorrow? In other words, should we issue a decision that says this is exactly the way these cases ought to be handled?
I'm sorry, I'm not
The whole
sure I
scenario
understand.
that took place in this. If someone decides they want to tear up a child's life by doing something like this, it is absolutely appropriate, and we should sanction what went on in this case.
No.
Okay.
Suppose you win this case, and Mr. Nell is required to pay support, and Mr. Sims decides tomorrow, I'm leaving and I'm not paying a dime. Can she go after him?
No. I don't believe you can go after more than one father.
So the result of that you're seeking here is to eliminate any legal parental bond between Sims and this child.
I'm not sure, other than the fact that he signed the affidavit of paternity, there has not been an order of affiliation.
Well, okay, to eliminate, but if you prevail, then there never can be any bond between any legal relationship between Sims and the child.
That's correct.
And shouldn't we consider whether that's in the kid's best interest before we order?
You could argue that, yes, you should in future cases.
Because in a different case it could happen. Let's assume the mother, decided to do this out of spite for the person that she's living with, her husband, who she knows is not the father, and he wants to assert a parental right. We could conceivably, based on this case, say it's too bad. We know you raised the kid. You sent her to school. You went to all her soccer games and everything else. But mom says dad's in Florida, so you are no longer interested in this child. We're not going to let you try to assert equitable estoppel against the real father.
Well, I think that in this case, the court, the family court judge, attempted to do so by summary judgment, whether it was in the looking at judicial economy, or that's how he decided to proceed.
Constable, once the DNA test was taken here, that's really the end of the story. Is that what you're saying?
Yes.
That's it, even though at the time that the DNA test was taken, he didn't know that he had a right to have counsel assigned. It's still the end of the story.
He did consent and said on the record that he wanted the DNA test to take place.
Well, wasn't he entitled to have a lawyer?
Yes, he was entitled to be advised of his right to assign
that's
counsel.
pretty harsh the other way and doesn't include the interests of the child, right?
That's correct.
You could foresee a situation, could you not, where you as the law guardian would object to, in this case, Mr. Nell, saying, I want to assert my rights. And you might say, look, he's in Florida. He's not, I don't want to talk about this particular person, but he's on welfare. He can't support this child. This child is in a family with a solid father, albeit not his natural father. The best interest of the child is to keep this family intact the way it is now. You could conceive of a scenario like that.
Yes, I could, Your Honor.
Okay.
But the result would still be the same, though, in your
Well,
mind. It wouldn't matter, the scenario that Judge Pickett just gave you.
In this particular case, and again, just looking at the facts of this case.
No, in this particular case, it wouldn't. Well, all right. In this particular case, if the father was in that circumstance, it still wouldn't matter. It doesn't matter if the facts in relation to the two fathers, whatever they are, the person that she's been growing up with and the biological father, it doesn't matter. The interest of the child has no consideration, the DNA test, over you're stuck with the biological father, whether it's good for the child or not, and we don't do a hearing, does that make any sense to you?
Well, I don't know that I'm saying that there shouldn't have been a hearing.
Aren't
Unfortunately,
you backing off from that? Earlier you endorsed the appellate division rule of biological father always pays no matter what. It sounds to me like you're qualifying that.
no, I'm not. I think that the father should pay, and I think that...
And you also say that if he pays, nobody else has to pay.
Correct.
So what about the facts of Shondell? Shondell won her case against Mark. Let's suppose the morning after she does that, she says, "Oh, I remember who the real biological father was. I'm going to sue him." Can that guy defend? I mean, wait a minute. She's already got one father?
Well, if the other person has been legally adjudicated as the father, yes. I believe you can only have one legally adjudicated father. There is no legally adjudicated father in...
So the first one to get adjudicated loses.
Well, again, I would say
So
not loses.
the biological father does have a defense if someone else has been legally adjudicated.
I think that is a completely different situation, yes. But in this case, Ms. Aikens was not married to Mr. Sims at the time that this child was conceived and born. So there's no presumption of legitimacy that comes into play.
Does this child's surname get changed now also?
I think that would be a decision that the mother would make. I don't believe that the biological father can force that to occur. The birth certificate can be amended to name the actual biological father, but her surname does not necessarily have to be the same.
But again, there's no consideration of the child, what would be best for the child. In any of these issues, everything flows automatically once you know who the biological father is.
The reason that my client is taking the position that Mr. Nell should not be allowed to deny his responsibility to her is unique in this case because she knows that he knows that he's the father. Now, but
the uniqueness of the case doesn't seem to help you when the appellate division decided this on a broad, sweeping rule that says biological fathers lose.
I would say that the appellate division rule that equitable estoppel can't be used as a sword is correct, because then we would have the reverse situation where we have...
But the uniqueness of this case doesn't make it correct.
No, this case is unique.
It may be unique, but that is not the basis for the appellate division decision.
That's correct.
What about the right to counsel issue? Why shouldn't we reverse on that basis?
Well, as I set forth in my reply brief on behalf of my client, I believe that the counsel that did appear, are you talking about the advisement of the right?
I'm talking, yes.
Yes.
Yes,
I cannot deny, Your Honors, that there were some procedural errors made by the lower courts in this case.
Well, it's a pretty significant one,
Yes.
wasn't it? Why isn't that reversible error in and of itself?
It could be, if the court so choose to decide that way.
Wasn't there also some rather serious deficiencies in counsel's performance? I mean, I've never seen a transcript where the judge says, "Have you talked to your client?" and the lawyer says, "No, actually, this case fell between the stools," and they then have a hearing at which the lawyer examines this client he's never spoken to, asking questions that he doesn't know the answer to. Isn't that kind of problematic?
Again, I agree with you. However, as far as the attorney himself, he was not given the opportunity to do other than how he was directed to proceed by the judge.
Maybe it's not his fault, but it doesn't seem like, I mean, is that really adequate assistance of counsel to be put on the stand by someone who's never spoken to you and has absolutely no idea what you're going to say?
Under the circumstances, I would say that ideally, again, mistakes have been made procedurally in this case. When we look at the entire scope of the representation, the fact that papers were presented, motions, it was transferred to the family court judge. Again, I think there was effective assistance, and I would again point to the argument that I made.
You don't think there's any question about that?
Pardon?
You don't think there's any question about that? Effective assistance?
There is a question, and I would say, as I said in my reply brief, that it was effective assistance, and that, again, as perhaps an aside, that this court should...
Could we determine that in what we know?
Yes.
What's the right standard?
Well, counsel and I differ a great deal on that, and I would say that there should be a stricter standard
So you
imposed.
say prejudice.
Pardon?
You say prejudice. Actual
Yes,
prejudice.
I do. Where,
Because you say essentially the biological father always has to pay. So sort of by definition, there could never be prejudice. Well, why even give him a lawyer? I mean, what's the lawyer going to do? The DNA test is the DNA test.
well, I think effective assistance can be raised in cases that perhaps in the future where there hasn't been a DNA test yet. There's hearings, there's different procedures.
So basically you're saying that if we know, however we know it, that this respondent really is the biological father, then the right to counsel is irrelevant to the case. You know, it doesn't matter if he was pro se the whole time.
I don't believe that that's what I'm saying, Judge Smith, but I would say again that the characterization, with all due respect, that the biological father loses, I think the biological father lives up to his responsibility for support.
Or loses or has the benefit of fulfilling his responsibility to pay money.
Yes.
Yeah.
He was also not prevented by, after his knowledge, back when my client was 6, that he was the father of this young lady, to file a petition at that point to contact her, to have communication with her.
Well, what about the time, I mean, I guess we have to assume it's true at this point, that when he did call the house, the person in the father-like relationship said, don't call again.
There's no order of protection. There's nothing legally preventing him from filing a petition in family court at that point. And he could have done so.
Okay, counsel.
Thank you.
Counsel rebuttal.
Thank you. Chief Judge, just in response to a point that you raised, Shondell specifically holds that even though the DNA tests have already been conducted, family court is authorized to decide the estoppel issue. So I don't think it's dispositive that the
Right,
tests
that doesn't end the story.
No, right. And I also think that I'd submit that Mom has an equitable estoppel action against her husband in this matter. Her husband assumed this role of father figure, lived through now 16 years almost.
So we do have 2 fathers, both of whom have support obligations, potentially?
Did you release your decisions from last term?
They're on their way.
Good answer, yes.
Well, what's the answer?
What's
What's your answer?
My answer is there's one father who has one obligation, and it's the father figure in this particular
So
case.
what are you suggesting
And Mom's
that our remedy is here? How far do we go in describing what has to happen if we agree with your position?
Again, I think in dicta you can certainly say Mom has a cause of action against her husband. I think the appropriate remedy here is to remit it for fact-finding hearing before a new judge.
Is Mr. Sims an indispensable party here?
Yes, and I think the case law says that he has to be joined here, and I think that's implicit in any best interest determination. You have another party here who has an ongoing relationship and an intact family with this child. Yes, I think he has to be there, and his testimony has to be heard, and I think probably a Lincoln hearing has to be conducted in this particular case. I just want to touch briefly on the right to counsel violation.
Yes, go ahead.
I don't think this was, my client waived his right to counsel in any respect. I think the magistrate erred, his attorney was ineffective. This is a pool cleaner. You can't expect him to be asserting these very complicated legal issues.
So you don't think that when your adversary says that he agreed to the DNA test, that that's the end of the story?
I don't think that
At least it's
finding
the
on-
counsel issue. Yeah.
I think the magistrate's error in failing to advise him was a per se violation of his constitutional rights. I would ask the court to consider, if it's going to articulate a standard for these cases, that Baldi Benevento should be applied. I say that because, first of all, it's already applied in J.D. cases where there's some quasi-criminal conduct, but there's the potential for that same kind of conduct in any family court case where there's a willful violation. I think due process in family court is the same as due process in criminal court, and of course the right to counsel derives from the right to due
Okay,
counsel.
counsel.
Thank you.
Thank you. Thank you both.